Yes.
My Lords, just to finish the topic that we were on before the short adjournment.
I think you need your mics on.
Thank you, my Lord. Just to finish the topic we were on before the short adjournment, we say that the word may in the Schedule 3 power gives the Secretary of State a discretion in a way that the word may in the Prison Act does not give the governor. The governor must detain pursuant to an order of the court. In my Lord Kerr's phrase, the authority exhausts the legality. In that context, that is not the case here. And of course, it was anathema to executive detention, which is what caused the furore around the control order litigation. My lords, my lady will be well aware that it is only a court that can make a derogating control order. The executive can't. My lords, can I just give you just one more policy reference which I missed, and that is to the white paper, which again talks about the importance of administrative review, and that is volume 2, tab 13, chapter 12.10. My lords, looking at it.
Yes.
Um, 12.13.
How does the bail system fit into this? I mean, you've got, as it were, two parallel systems. You've got the right to apply for bail, I suppose. Yes. There's no regular system. Is it, the initiative lies with the detainee to apply for it.
Yes.
And then you have the system you've been describing to us. But,
yes, it's the system in the schedule, paragraph 22 of Schedule 2, which is applied across to Schedule 3 cases.
Schedule 2, paragraph 22.
Yes, I didn't show you another paragraph. It was Schedule 2, paragraph 29, which is bail pending appeal. That's also applied across to Schedule 3 cases. But that's at the instance of the individual.
Yes.
How often? Any restrictions on frequency?
There's no restriction.
Okay.
There's a restriction at the initial stage. You can't, if you're being detained pending examination, you can't apply for bail until 7 days have passed.
Is there any decision on yes or no whether the Hardy-Singh principles apply on an application for bail?
They don't. There is a decision called Conan, and they don't apply because the starting premise of bail jurisdiction is that the detention is lawful, otherwise you couldn't action a breach of bail.
I mean, I don't understand Mr. Tan to accept that. I had rather got the impression that he thought on a bail, he suggests on a bail application you can contest detention on the basis that it offends the Hardy-Singh principles. I may be wrong.
Logically,
I hope you'll tell us if I'm wrong, because otherwise...
Logically speaking, there'd be no jurisdiction to impose any conditions at all, or any reconnaissance if that was the case.
Sorry?
You couldn't impose conditions as a tribunal. If detention's too long, it's too long.
I know, but why can't the court to whom you apply for bail say so? Say that this is
because the tribunal only has jurisdiction to grant bail. It doesn't have jurisdiction to grant release. And it isn't. It's never been the case that you could appeal to the appellate authority, the immigration appellate authority, against a decision to detain. That's never been an appealable decision.
What are the criteria for bail?
There's nothing set out in the Act itself, oddly. The fundamental issue, as I think Mr. McAlue's statement, the intervener, indicates, is the question of abscond risk. I think I said before the short adjournment that there was proposed an automatic system of bail hearings for all those detained under Section 44 of the 99 Act. That was never brought into force.
No, you tell us that.
And it was repealed.
Well, I mean, if there is a case which says that on an application for bail, it must be assumed that the Hardy or Singh principles are being complied with, I should certainly want that authority if there is.
It's Conan tab 74,
Bundle.
bundle 8, paragraph 30.
This is a single charge.
Mr. Justice Collins,
Paragraph, sorry.
30. Mr. Kambadzi submitted a judicial review as inappropriate since bail was an alternative remedy and it was a collateral challenge to the refusal of bail. Both points thoroughly bad. In adjudicating considering bail application is not determining, indeed has no power to determine the lawfulness of the detention. The grant of bail presupposes the power to detain, since a breach of bail can lead to reintroduction of the detention. This was also an issue in the Belmarsh litigation when Mr. Justice Collins considered that bail could be an ultimate remedy in a situation where indefinite detention was breaching Article 3 rights. And the interesting issue which arose was if detention is so bad as to breach Article 3 rights, then you can't bail, because you can't action a breach. That was the case of G.
Well, I don't think that advances this case. I mean, it may be different.
No.
But either way, it's Mr. Justice Collins who takes the view that bail is not a basis for invoking the Hardy or Singh principles.
On the other hand, it says at the end, in truth, as I said, while no doubt concerns about the lawfulness, potentially the issue raised might weigh in a decision
Yes.
on bail.
Yes, that must be right. As a matter of practical reality, it must be right. But strictly speaking, if detention is unlawful, the adjudicator cannot grant bail.
Well, he
It's a
could
paradox.
grant bail, suggesting at one and the same time that actually the chap would be well advised to challenge the lawfulness of the detention.
Indeed.
I would have thought that was
Indeed.
a better view.
But bid explain why this is not an adequate...
I'm not asking for that. I just want to know what the position is. I mean, I mean, you know, it's a difficult case, and we've just got to see where the problems lie. How far
Indeed.
they are.
My Lord, yes.
The trouble is, if it's not possible to grant bail on conditions, it makes it all the more likely that people will want to detain people for obvious reasons, for the reasons that they wanted to detain your client.
Yes.
Whereas if bail is possible,
Yes.
it makes it much more likely that it would be possible to grant them bail on the basis that they keep in touch, they report at various times, and the like.
Yes. My client
So
would,
from
in
a
fact,
policy point of view...
So can you not grant bail subject to conditions?
if detention is unlawful, then you can't, no, because the conditions couldn't be actioned. You couldn't re-detain. You'd be re-detaining.
If somebody is going to contest the thing, but he makes a bail application and the judge thinks, well, there might be something in that, as it says there, it might weigh and so on and so forth, the adjudicator thinks that, can't decide it, of course, but it weighs, but on the other hand, thinks, of course, that you better make quite sure this chap doesn't abscond, therefore he better report to the police station every morning. I mean, can you not do that?
No.
There's no power to impose conditions on bail.
No, if detention is unlawful, then he's plainly can't.
He's not deciding it's unlawful.
Oh, no. Well,
Sorry, can we see, have we got this section on bail?
Well, it's paragraph 29 and 22 of Schedule 2. 29 is bail pending appeal, and 22 is bail solicitor, I think. And they don't actually mention a power to impose conditions. It's just simply a power to grant bail. But surely the concept, when it talks about a bail bond, look at 29.2.
yes.
a bail bond conditions for his appearance, time and place named in the recognizance or bail bond. A bail bond conditioned for his appearance before the tribunal. So 29.3 does seem to indicate that if you're asking for bail pending an appeal, it can be subject to the condition of appearance at the tribunal hearing.
But the whole concept of bail is that it's conditional on something. This was the problem in the G case. Mr. Justice Collins had devised a route out of the indefinite detention created by the 2001 Act by saying bail could be an ultimate remedy. And there were problems with that view expressed in the Court of Appeal. I won't go into the litigation now, but the fundamental proposition was you grant bail as an interim remedy pending something else. If the underlying detention is unlawful, you can't do that. But I accept my Lord's point that the issue will weigh. Of course it will.
But I mean,
And actually 22.3 does talk about conditions as well.
Absolutely, of course.
There it is.
Yes, may.
Condition for his appearance.
It's amounts and conditions.
I mean, if you apply for bail on this, who do you apply to?
The tribunal, there is also a power in the immigration officer to grant bail.
But under paragraph 22 of the second schedule?
29 to an immigration officer.
Yes, it's 22 1A. An immigration officer not below the rank of the chief immigration officer or the tribunal.
I haven't got a 22 1A.
Sorry?
22 1.
22 1A.
Yes.
Yes, you see you're using it.
Oh, I'm using an out-of-date text, am I?
But is 29 applied to by Schedule 3?
Yes, it is. It's Schedule 3 to para 2.4. I'm sorry, it's Schedule 3 para 3.
2.3.
Not 2.3, Schedule 3.
Para 3. It is,
There are
yes.
3 unless released
Yes.
on bail.
Yes.
And what happened in this case, I think there was an initial refusal in May 2006, presumably by the immigration officer.
No, the tribunal.
Oh, the tribunal. Then the tribunal did refuse again.
Yes.
When, I think in September of that
September
year.
06, yes.
But the initial one was by the tribunal as well, was it? The initial refusal was
Yes,
tribunal.
yes. And then he was, in fact, granted bail in June 08 by the tribunal.
And that was because he'd appealed in April. And so the progress of events, appeal in April, applying for bail in May, bail refused. Then the hearing by the tribunal in September, I think, and then they refused bail at that stage again.
Yes.
And that's the last we hear of bail, I
Bail,
think, in the
yes.
history.
But we respectfully submit that this is not an adequate substitute for a review for all the reasons which Mr. Fordham's clients outline, and the point that Mr. Justice Munby made, that in a bail application, the Secretary of State is likely to take a forensic position. That is at, I'm sorry. I'm sorry, my lords. It's paragraph 74.
Oh, sorry, this
Mr. Justice Munby,
74.
74, where he says, bail is no more than a forensic decision as to what stance to adopt in a situation where someone else, the immigration judge, is the arbiter. The other is an exercise in substantive decision-making where the Secretary of State is herself the decision-maker. And of course,
can I just wait? I just read this one.
And there's a deeper point which we make at paragraph 50 of our printed case, which is that Article 5 supports us in this regard.
What?
Article 5 supports us in this regard. Because what Article 5 says is that the deprivation of liberty must be in accordance with the procedure prescribed by law, and that is at the executive level. The executive must act according to law when they're depriving an immigrant of his liberty under 5.1f. And Article 5.4 requires access to court for supervision at the judicial level. And as the court in the HL case, the Vaughanwood case, said, these are two distinct and cumulative protections, and that's at paragraph tab 123, paragraph.
What bundle's that?
123. It's at bundle 19, my lord.
19.
I don't think there's a 19.
Oh, sorry, I've gone completely.
What?
It's volume 14.
40.
Yes. Yes. That's HL 123. And the paragraph number?
123. At page H01.
Yeah.
The government's submission that detention could not be arbitrary within the meaning of 5.1 because of the possibility of a later review of its lawfulness disregards the distinctive and cumulative protections offered by paragraphs 1 and 4 of the Convention, of Article 5 of the Convention. The former strictly regulates the circumstances in which one's liberty can be taken away, parentheses, by the executive, whereas the latter requires, in a 5.1f case, whereas the latter requires a review of its legality thereafter, in parentheses, by a court.
And is it part of your point on bail that bail is not reviewing the legality of the detention? It's a mechanism for temporary release on conditions, but if you're going to review the legality, you have to go to a hearing before the tribunal or before a court.
Yes.
Or you can conduct a review in which you take that decision as a matter of practice in the light of the information you've gathered on review. Then you terminate the detention at that point, if necessary.
Yes.
I mean, say the Home Office documentation provided for a review once a year.
Yes.
What's the position then?
Well, we addressed that in our printed case. We say the common law simply wouldn't allow that. It would say that's not good enough. Now, what the common law wouldn't do is prescribe the mechanics by which the review felt to be undertaken. It wouldn't stipulate time periods. It wouldn't stipulate seniority.
Sorry, where do you say that once a year would be unlawful?
We don't say that in terms, my lord, but we say that.
I mean, I rather doubt when this first came in there was any provision for internal review at all. I mean, I've no idea if there was or wasn't. But I mean, there may well not have been.
Well, for 19 years, it's been the case.
I know it has.
Yes.
We're talking of 40 years of legislation.
Yes.
Where do you deal with it?
I'm sorry, my lord. Uh, 48. At page 19. 19.
I mean, governments always believe, they as noticed one white paper, fast or something or other. They always believe that everything is going to go very fast. Yes, and it should do, of course. I mean, the real trouble about these things is that they take forever. And that's why you need reviews. I mean, if people were locked up quickly, the decision to deport them were taken quickly, they were out, reviews would be really beside the point. It's only because actually these things, these kinds of cases, drag on for years, that you then find yourself having to read in, if you like, or to tease out the need for reviews and so on. I mean, if it all were fast, there wouldn't be any.
We respectfully submit that exercising the power of detention is a dramatic step. You may be detaining somebody who is very vulnerable, who may be prone to mental illness, who may be a torture victim, traumatized, and therefore one needs to have a mechanism for picking up error. And if my Lord is, I'm happy to go along with my Lord's broad thesis, even on that account, we say they're essential, even on that premise, they are essential, reviews are essential, given the fact
You've got to keep an eye on people.
Yeah, and then, my Lord, there has been movement in Europe on this issue. In our printed case, we talk about, we refer to Directive 2008/115. This is an EC directive.
Paragraph of your case?
Paragraph 115, and the document is at 218. This is a directive from which the United Kingdom has opted out.
So two is it,
Sorry, volume 2, tab 18, I'm very sorry.
Tab 18 and 2.
Volume 2, tab 18. And the relevant provision is at Article 15.3 at page... I'm sorry, this isn't internally paginated. So Article 15 is detention for the purposes of removal. Chapter 4.
Yes.
Article 15.
At reasonable intervals.
Yes, either on application or ex officio. In the case of prolonged detention periods, reviews shall be subject to the supervision of a judicial authority.
So is that an additional requirement? First sentence is the basic rule, and then
Yes.
at long periods you've got the further requirement.
Indeed. Indeed.
It doesn't tell you what that is, what intervals that is.
No, that's again left to the discretion of the national state.
and has the transposition not taken place yet, or is it? Till 24th of December 2010.
Yes,
So we've opted out.
So we opted out.
The UK's opted out.
I beg your pardon, Mr.
The UK's opted out.
I'm very sorry.
But we deploy this provision for the purposes of informing what would be the position under Article 5. We set out our argument at paragraph 116. Mr. Fordham has a better point in his case. Oh, I'm getting lost in my notes, my lord, I'm so sorry. Yes. 41.5. What we say is that Article 5, this is our case at 116, Article 5 falls to be construed in harmony with the rules of international law of which it forms part.
So you say the intervener is at 41.5.
It's page 19.
Deals with it at paragraph
Paragraph 41.
Yes,
41, subparagraph 5.
it's page 19 in the document, I think.
Case for the intervener. My paragraph 41 says consequences.
It's 41.5 at the top of
Oh
page
no, I'm
19.
terribly sorry. I'm looking because it's attached to the witness statement. I'm so sorry. Thank you. Sorry, my fault entirely.
So the point that we make 2 points of principle. Mr. Fordham makes a better point of practical implementation. We say the Alatsani point, Article 31, Vienna Convention, Article 5 has got to be construed in light of, in harmony with the rules of international law of which it forms part. This is a rule of international law of which Article 5, protection against detention, forms part. We make the Bosphorus point that the community guarantees protection to fundamental rights on an equivalent basis to the convention. Mr. Fordham, in his case, says, well, the court has construed convention guarantees in the light of international instruments which the respondent state had not ratified. But this is evidence, we say, of an emerging European norm. And then, my lords, we have at tab 177, volume 18, "20 guidelines on forced return." This is volume 18, tab 177. This is a document entitled 20 Guidelines on Forced Return, adopted by the Committee of Ministers of the Council of Europe. You see that from the preliminary note. And if my lords go to guideline 8 at page 30, something which is similar to what one had in Article 15.3, length of detention 2. In every case, the need to detain an individual shall be reviewed at reasonable intervals of time. In the case of prolonged detention periods, such reviews should be subject to the supervision of a judicial authority.
Yes.
That is something which goes beyond the simple reiteration of existing binding norms. And gets that from page 7 and the use of the word should.
Yes, but my lord, these are instruments which we say Article 5 would fall to be construed in the light of.
But it doesn't imply any new obligations for Council of Europe member states.
No, it doesn't, no. Mr. Fordham reminds me that the directive uses the imperative shall.
So it shall in the first line, should in the second, and shall is...
Shall is existing.
yes.
Yes, paragraph 2, first sentence, shall. And
Strasbourg have never had a case, have they, on pre-deportation detention?
It's that
Well, Chahal was.
they've had
Yes,
many.
of course they've had Chahal, yes.
They've had Chahal.
Does that throw any light on our problem?
No, the issue doesn't arise in that case. There are other cases of Article 5.1f detention where there have been problems of review, and the court's gone for the maximal point, which is access to court. So Amour in France, there was a problem with the asylum seekers who were detained in the Amour case couldn't get access to a judicial tribunal to consider the legality of their detention. But my lords, I'm very happy to answer any other questions my lords have on the interrelationship between judicial remedies and the need for executive review. I was going to move on to briefly develop my 9 points. I've covered a lot of terrain, if I may say so. But if I can just pick up some points, and there are some points which haven't been developed. I'm very happy to address any other...
Well, I think you should make progress, and we'll no doubt ask questions as you go along.
My lords, the first point, we say that review is essential to the legality of continued detention because it is the exercise of discretion to continue to detain. Mr. Tam draws a distinction between an initial decision to detain and a decision to continue to detain. And you get that, my lords, at paragraphs 4 Roman 1 and paragraph 68 of his printed case. Paragraph 68, it is the paragraph where the case of Holgate Mohammed appears. A single footnote reference in his case. It's footnote 23. I should perhaps say, with very great respect to the eminent counsel appearing below in this case, Holgate Mohammed was not cited to the Court of Appeal, except by Mr. Tam, and that was on an ancillary point. It wasn't cited to the Court of Appeal for the proposition that the tort of false imprisonment can be constituted by a public law error in the exercise of an executive discretion pursuant to statute, even though the statutory condition precedents for detention are met. Mr. Tam says Mr. Tam says that Holgate Mohammed concerned an initial arrest, but we say that's completely beside the point. Imagine a situation which occurred in the case of Plange.
Case of what?
Plange. I don't need to take you to it. It's volume 6, tab 47. But that was a case where the issue was whether or not, although the statutory preconditions had been met, the issue was whether or not the arresting officer knew that there would be no charges brought, because the complainant had decided not to cooperate. Now, that situation could occur at the initial stage, or it could occur 5 minutes after the arrest, it could occur an hour after it. So there's no magic at all in the idea that Holgate Mohammed concerned an initial arrest only. And what that indicates is that where executive detention is concerned, police powers, immigration powers, a detention that is lawful ab initio may well become unlawful with the effluxion of time. And that proposition is very well established. You have it in the John Lewis and Timms case in 1952. Again, I don't want to take you to it, but it's volume 4, tab 32, page 691. implicit in Hardiel Singh itself. And I just want to give you two references to two immigration cases where this analysis has been adopted. The first case is AKB, ex parte AKB, at volume 6, tab 55. This was a case of Schedule 2 detention where the judge considered, Justice Kay considered the 91 and 94 policy documents, which you've seen. He held that initial detention was lawful, but when further evidence was received by the Home Office in support of the claim the individual was making, it was, and I quote, necessary for an urgent reappraisal of the detention situation. And that's at page 324D of that report from my Lord's note. And he held that detention was unlawful after a period of time that was reasonable for the Home Office to consider that material.
That's a straight application of Hardiel Singh principle, was it? I mean, I'm asking.
He says that the detention to detain was against the weight of the evidence. Now, query, but that's not classic public law error. We're pre-proportionality in 1998 AKB. You're into Tesco stores territory where weight doesn't go to a public law error. It's not clear, but it looks as though he was applying, at least applying the policy. In the case of Johnson, it's clear that this was a policy case. Johnson is at volume 8, tab 73, paragraph 28. This was a case of a 64-year-old man detained at Oakington, the process considered in Sardi. Mr. Justice Jack found that his detention should have been reviewed. That's at paragraph 31. And it should have been apparent after 6 days that his claim would not be adjudicated upon within the Oakington timetable, which was 7 days. In fact, he was detained for some 2 months longer than that. And he was awarded damages for that period. And you get the 7-day target, so you get the 7-day limit from Home Office policy. So that's a case of initial detention lawful, need to review it, failure to review, unlawful detention.
And its 7-day policy applies up to 28 days. Is that the point? That after that you go on to a monthly cycle?
No, so, I'm sorry, my Lord, the context was different because this was Oakington detention, where you've got no abscond risk issue. This is detention just to process the claim, and the policy was we will detain only for 7 days.
Oh, I see, yes.
It's a different context.
Right.
I'm sorry if I'm taking it too shortly. So, my Lords, that's all I want to say about the first point, that the review is essential for the legality of continued detention, because it is the exercise of a discretion to detain. My second point concerned Roberts and the importance that we gain from the fact that the Secretary of State does not seek to dispute the reasoning in Roberts, indeed supports.
Before we look at Roberts, where is it?
I was going to take my Lord's aid. Roberts is at 757, volume 7, tab 57. Judgment of Lord Justice Clarkley then begins at the bottom of 663. The facts are set out at 664. So he was arrested at 10:50 p.m, taken to Northwich Police Station, where his detention was authorised at 11:25. And then this was the problem, because he was then escorted to another police station and the officers there thought that time limits only began from then, rather than from his earlier arrest. Detention was authorised to obtain evidence by questioning. He was asleep. The review was conducted, letter C, at 7:45 a.m. This was in fact 2 hours, 20 minutes later than it should have been. And the terms of the review are interesting case review, further detention authorised in order to obtain evidence. A further review at 5:20 p.m. and again the quotation, further detention authorised. And then charge refused, he was released.
So they didn't say they should have woken him up earlier, because they didn't wake him up even at 7:45. They merely said they should have gone through the process while he was asleep earlier.
Yes, there's a statutory provision
Yes, yes.
allowing for that. And that, of course, engages the Murray principle that the tort is actionable per se, and you don't need to show special damage. In fact, in this case, the court held that he was aware that he was detained even though he was asleep. If you fall asleep in a police station, you have a sense you're asleep in a police station, I imagine. The statute is set out at letter G, 34.1. A person arrested for an offence shall not be kept in a police station except in accordance with the provision of this part of this Act.
Where are you?
I'm at 664G.
Sorry, thank you.
Now, Mr. Tam and the Court of Appeal placed determinative reliance on this sentence.
So which sentence was that?
34.1. 665 in PACE. This is PACE section 34.1.
So it's the first sentence of the subsection, isn't it?
Yes. They say that it's that which makes the review in Roberts a precondition to legality of detention. We say no, because you could have had other conditions specified in the Act, in that part of the Act, such as access to a solicitor. But the fact that the section required compliance with that statutory condition would not make your detention unlawful and give you a claim. And Cullen is a very good example here.
Sure.
So it's 37.1, where a person is arrested without a warrant, the custody officer shall determine whether he has sufficient evidence to charge. Over the page, if he doesn't, the person arrested shall be released unless he's got reasonable grounds for believing that his detention is necessary to secure evidence. And then 3, if the custody officer has reasonable grounds for believing, he may authorise the person to be kept in a police station. And that's what happened here. You had 2 and 3. Then 40, section 40, subsection 1, reviews of the detention of each person in police detention in connection with the investigation of an offence shall be carried out periodically in accordance with the following provisions. And then B, in the case of a person who's been arrested but not charged by an officer of specified rank, he's a review officer. And then 3, subject to subsection 4 below, the first review shall be not later than 6 hours after the detention was first authorised, and then 9-hour intervals. And then 12, subsection 12, the language is interesting, before determining whether to authorise a person's continued detention. So this is executive detention, where the individual retains his liberty, and the question is whether the officer is to authorise continued detention. The review officer shall give that person, unless he's asleep, an opportunity to make representations and so forth. And then at letter G, distinction is drawn, this is Lord Justice Clark's judgment, letter is drawn between the powers of the custody officer to authorise and to review. Letter H, in these circumstances, the judge held the plaintiff was unlawfully detained as from 5:25 a.m. I agree. Section 34.1 is mandatory. The plaintiff was detained at 11:25, so review should have taken place by 5:25 a.m. No such review took place. From that time, he wasn't being detained in accordance with relevant provisions. His detention was unlawful. Then Clark and Lindsell is quoted from. The submission is recorded of counsel for the police at just above letter C. Ms. Benson submits on behalf of the defendant that the plaintiff could only prove false imprisonment if he could show that the review had been carried out at the appropriate time. He would have been released. So that's germane to the causation issue. It is common ground that the plaintiff could not show that he would have been released, because there is no doubt if a review had been undertaken at the requisite time, his continued detention would have been authorised for the same reasons as it was subsequently authorised at 7:45 a.m. No doubt that the reason why there was no review was the mistake to which I referred earlier. And then passages from Clark and Lindsell are quoted, and over the page, I should just read the quote right at the bottom of the page, 666. In relation to detention under the Act of 84, the situation is different. On the expiry of the prescribed period of detention, any authority to continue the detention of the arrested person ceases to exist, and continued detention is unlawful. So authority to continue detention. Over the page, at B, Ms. Spencer submits, long as circumstances existed which were or would be sufficient to justify continued detention, the plaintiff could not be fairly to be said to be detained without lawful excuse. Unable to accept that submission, 5:25, he wasn't being detained in accordance with the Act because no review was carried out. It's nothing to the point to say that detention would have been lawful if a review had been carried out. Part 4 exists in order to ensure that members of the public aren't detained save in defined circumstances. Well, the equivalent policy framework equally exists to give protection, as my Lord Roger was putting to me some moments ago. In all other circumstances, every member of the public is entitled to his or her liberty. Well, aliens equally have the right to liberty. It's not contested by Mr. Tan. In this, after the quotation from the Hill case, the plaintiff was entitled to a review. His further detention was unlawful. He was being deprived of his liberty without lawful excuse. And then this, at letter F, the plaintiff wasn't in fact released until 6:55 p.m., 13 and a half hours later than the specified review time. The judge held he was being unlawfully detained throughout that period. At the trial, it was accepted that if, contrary to the defendant's case, detention was unlawful after 5:25 a.m., it remained unlawful until he was released. Whether that was so or not had no effect on the outcome of the trial, because it's common ground the judge awarded damages £500 to compensate for unlawful detention for 2 hours 20 minutes between 5:25 and 7:45, when the late review took place. It was not suggested that the review took place approximately at the right time to save it under 45(2) of the Act. In these circumstances, it isn't necessary in order to dispose of the rule, to analyse a true legal position from it says 7:25, it should be 7:45. I think that's a typographical error. From 7:20 to 7:45, I'd only say that for my part, I'm not persuaded that the plaintiff's detention after 7:45 was unlawful. It is true he wasn't formally rearrested at that time. The police didn't think it necessary to do so because they thought that they were complying with the Act. However, there is no doubt they could lawfully have rearrested him at that time because there were grounds upon which to do so, not necessarily to decide whether rearrest was required. It might be thought to be unnecessary because the plaintiff was already in police custody. It seems to be arguable, although the first review was late, nevertheless a review was sufficient to make the continued detention of the plaintiff lawful as from the time it took place. On that footing, the next review should have taken place 4:45. It took place 35 minutes late, but wasn't investigated at the trial. Then the question of damages. £500 were awarded to compensate the plaintiff for his detention for 2 hours 20 minutes. The judge accepted the submission that the error was largely technical, which made no difference. The reality is a more legitimate complaint can be made about 2 hours 20 minutes when there should have been a review and there wasn't. And then at D, 668D, it is my view that this was an infringement of the plaintiff's legitimate rights to have his case reviewed. Well, we have legitimate case to have our rights, to have our case reviewed. And that although the outcome may not have been affected by the failure to review in time, this infringement cannot be regarded as a purely nominal matter or a matter compensatable by entirely nominal damages. There are rules. The police must stick to them. Mr. Tam accepts that in his case. And this plaintiff was certainly being held for 2 hours, 20 minutes, whilst he was entitled to have his custody reviewed. And that is, although the overtime is 13 hours to 30 minutes, essentially the gravamen of the matter, no mala fides, good faith, error was technical. And then the discussion about whether or not nominal damages only should have been awarded. At first, letter F, at first sight, it seems wrong that a person who, but for the unfortunate mistake that was made, would have been detained throughout the relevant period, should be entitled to recover damages for his detention during that period. And then at just under G, as a matter of general principle, the plaintiff is entitled to be put into the position in which he would have been if the tort had not been committed. That's the basic restitutionary principle in any system of law of torts. It is therefore important to analyse what the tort is. The plaintiff's claim was not for damages for breach of duty to carry out a review at 5:25 a.m., but for false imprisonment. Equally, in this case, we don't assert a right that we had some actionable duty pursuant to the policy or pursuant to some act. As a matter of statutory duty, we firmly base ourselves in false imprisonment. A point my Lord Roger raised before lunch and adjournment. And then next paragraph, second sentence, the wrong was not, however, the failure to carry out the review, but the continued detention. If the wrong had not been committed, this is a false imprisonment, the plaintiff would not have been detained between those times. As a matter of principle, he is entitled to be compensated for having been detained for that time. And then a reference to the Murray case. This is a case where Lord Griffiths was tempted to recast law of tort so as to require special damage before it was actionable. He resisted the temptation to do so because the law attaches supreme importance to the liberty of the individual. You get that from the quotation just between C and D. Supreme importance to the liberty of the individual. And then the suggestion that he should only get nominal damages, I was at first attracted by that submission. Further consideration, I've reached the conclusion that it doesn't assist. And then reference to the Meering case, which Lord Griffiths preferred over another case where it was suggested that you had to be aware of your imprisonment. And then letter F, all depends on the circumstances. The person who was falsely imprisoned, who was unaware, would be entitled only to nominal damages. The plaintiff was not, however, in that position. He was no doubt aware of his imprisonment and therefore entitled to damages. And then just under letter H, a sum of £500 is substantially more than I would have awarded to compensate the plaintiff for false imprisonment for a period of 2 hours, 20 minutes, during which he was asleep, especially in the circumstance in which if a review had been carried out at 5:25 a.m., his detention would have been lawful. And we say...
I it's quite difficult to follow exactly how... Could you just help me? When His Lordship says, if the wrong had not been committed, the plaintiff would not have been detained between 5:25 and 7:45. How does that work? I'm just lost.
One has to identify what the wrong is. Is the wrong simply the failure to conduct a review?
Yes.
Or is the wrong that you were unlawfully detained? And that's what Lord Justice Clark says.
Yeah.
You've got to identify the wrong correctly. And you've got that, the final paragraph of 668. The wrong was not the failure to carry out the review. He's not claiming for an actual duty under the statute to the review. For the review. He's not saying, I've got a statutory duty. There's a statutory duty on you, the police, to conduct a review. It's intended for my protection. I'm a special class and so forth, and therefore Parliament intended that I should be able to recover damages for breach of that duty.
But he's saying...
That's not what he was saying.
What he's saying between F and G, at 669, as I understand it, is that he's to be compensated for being unlawfully detained.
Yes.
But that is because, in the absence of a review, he should have been released.
Yes.
Just simply because there was no review.
Yes.
Right he goes.
Yes. The review was authority for continued detention.
Oh, I see.
But that begs the question in our case.
Well, it does, but it demonstrates that if one accepts...
If you get the right answer, you get the money.
Yes, but Roberts is not contested for this court. Mr. Tam does not say this is wrongly decided. He distinguishes it on the basis that there's a statutory duty to conduct the review.
Under Roberts.
Under Roberts.
I mean, that's what comes through at page 667B to C, because you've got to be detained under the Act, he says.
Yes, but my lord, you could have a protection which has nothing to do with the detention. You could have a protection in the Act which required you to have access to your lawyers. Section 58, in fact, does provide for that. But a breach of that wouldn't go to the detention. The issue between us, in reality, is one of source or status. What is the status of the requirement to conduct a review? In Roberts, it was a statute. In our case, it's public law. Should that make all the difference? Well, we know that all public law errors render an executive act a nullity and ultra vires the statute. Unless one wants to reinvent, after 41 years since Anna's Minute was decided, unless one wants to reinvent categories of legal error and say that there are statutory errors which go to jurisdiction and public law errors which don't go to jurisdiction, they don't render a decision ultra vires. There are gradations of nullity. Certain errors render a decision a nullity, others don't. If one wants to go down that route, and that is what Mr. Tam is committed to, then you draw a distinction between Roberts and our case. But if Roberts is correctly decided, then we would say with respect that no distinction can properly be drawn, and the dispute as to status or source of the obligation cannot bear the weight which Mr. Tam seeks to put on it. How does one explain Lord Diplock in Holgate Mohammed? You don't do it in a footnote to a case.
I'm sorry, it's just, I'm trying to understand the actual result here. If one looks at page 666, C to D, the Lordship says that its common ground is very big that the plaintiff could not show that he would have been released because there is no doubt that if a review had undertaken 525, continued detention would have been authorised for the same reasons it was subsequently authorised at 745. Yeah? So that seems to be saying that if there had been a review at 525, he would have been detained.
Yes.
The wrong was not, it says then at 668, I'm just trying to understand it. 668H.
Yes.
The wrong was not, however, the failure to carry out the review, but the continued detention.
Yes.
If the wrong had not been committed, the plaintiff would not have been detained.
Yes. I think what Lord Justice Clark is when Lord Justice Clark is using the word wrong, he's using it in a technical sense. It's the civil wrong.
Well, I can imagine that.
It's not the error. The civil wrong is the false imprisonment.
Well, he's really saying it because of what he says at 667B, isn't he? I thought you were saying that the statutory requirement, under the statute, review had to be in accordance with the conditions of the statute. If it wasn't, the statute wasn't complied with, then it was an unlawful detention.
Yes.
I mean, on the true interpretation of pace, you can only, on this scenario, you only have authority to detain for 6 hours.
Yes.
If you want to detain him any longer, you have to have a review.
Absolutely.
They didn't have one, and that's the end of that case.
Yes.
But I mean, as we've just agreed, I mean, that begs the question here, where there isn't anything in the statute which says anything of that sort at all.
But there's...
Of course, there's all the policies. We don't need to rehearse them again.
No.
And the question is, are they to be regarded as, for all the world, as if they're in the statute?
Yes, but what we get from Roberts, with respect, my lord, is the idea that, and this comes out, if I may say so, very clearly in Mr. Fordham's printed case, what one gets from Roberts is the idea that the review is very much linked to the authority. And that's not a feature of the statute. It's a feature of the concept of a review. There could be, I think my Lord put to me before the luncheon adjournment that Mr. Tam is saying, yeah, you need the review and you need the statute in order for false imprisonment to run. The requirement for a review and the statute. And we say that on analysis, it's all you need is the review, because in a situation where you have executive detention, where there is an underlying right to liberty, and circumstances may change with the effluxion of time, you've got to justify continued detention. That's what all the policy documents say. It's what all the forms say. It's what the judges below said, Lord Justice Keenan, Mr. Justice Mumby. It's what principle says. Because we are not in the court order situation.
If the detention is unlawful, it matters not whether that condition of unlawfulness arises from a statutory requirement or from the breach of a public duty. In both instances, the detention is unlawful, and that's what provides access to the remedy.
My Lord, that's exactly our case, yes, indeed. Because the tort is constituted by detention without lawful authority. Lawful. Not detention in the absence of statutory authority. Not detention in the absence of substantive public law authority. In the absence
question is whether the public law... I'm so sorry. No, I'm sorry. I thought...
No, my Lord, I'd finished.
Well, the question is whether the public law duty that we've got in our case is to release unless you are reviewing, or to review. We're begging the question. I mean, the public law duty could perfectly well be to review the case, and if you think that the person should be freed, free him. But it doesn't follow that a breach of that public law duty means that when you don't have a review and accordingly don't free him, he's wrongly imprisoned.
I think I would agree with my Lord that the whole thing turns on the default position.
Absolutely.
I think you agreed with me, and I'm sorry to take you back to it again, page 266 in the appendix, to the rule, the detention centre rule, paragraph 9.1.
Yes.
And if that was all there was,
Yes.
you would agree, wouldn't you? That doesn't tell you that the detention without the review that's being talked about is unlawful. I thought you agreed with me. That doesn't go far enough. They're just simply saying you must have written reasons, and if within a reasonable time, if requested, then you could be given updates and so on about the reason why you're being detained and so on and so forth. Yes. Information is being given, but it doesn't say if you don't do that, you must release. And it's not using the word authority either.
No.
So this doesn't go far enough. You've got to go further than that.
My Lord's drawing me into difficult territory. I don't need I can accept that in order to succeed in this case. Mm-hmm. And I'm content to accept it. But my Lord's question raises very serious questions, because it is well established that a failure to give correct reasons, or a failure to give any reasons at all, will render an arrest unlawful. That's Christian Liczynski. That's the first point. The rationale for the requirement to give reasons is that the individual has a right to liberty and they are entitled to know why they're being arrested so they can resist arrest. Reasons serve a multiplicity of functions.
I thought we weren't having to decide all this in this case. You told us earlier we don't.
You don't need to, but my Lord Hope has asked
No,
a
I'm
question.
sorry, I'm just being perhaps too pedantic about it. I just want to see where we stand on that particular bit.
You don't need to decide it, but my submissions are, first of all, Christian Liczynski, and I hope I've explained my submissions and what the rationale for that. It's well established that reasons serve a multiplicity of functions. My learned friend Mr. Fordham has written about this. The functions are, first of all, they let the individual know why action is being taken. Secondly, they let the court know why action is being taken. Thirdly, and more importantly perhaps, they impose a discipline on the decision taker to make sure that he is turning his mind to appropriate matters. And then fourthly, they improve transparency in the system. And three of those reasons at least are cited by Lords Bingham and Steyn in the Cullen case at volume 8, tab 71. I'll give you the paragraph number in a minute. But that's the rationale for reasons. It runs in this context. If we had a case about unlawful immigration detention by virtue of failure to give proper reasons, and if that wasn't recognised, then we would be in difficult territory as far as the law, the state of the law is concerned, because you would have unequal law. You would have one law for own nationals and another law for aliens. And that's not acceptable. It's not acceptable because we know from Lord Bingham's lecture, the Cambridge lecture in 2006, The Rule of Law, expanded upon in his book that was published last week. We know from that when Lord Scarman in Khawaja talked about the equal protection of law, he meant the protection of equal law. It's all in our printed case. So at common law, that wouldn't be acceptable. And as far as the convention is concerned, you would have discrimination under Article 14 on grounds of nationality, which requires weighty justification, see Geigergesuch, and you'd have discrimination in the field of Article 5.5. Now, the problem with all those submissions is the case of Sardi. In Sardi, it's clear that the failure to give reasons was not argued before Mr. Justice Collins. I'll just give you tab references. It's volume 8, tab 66, paragraph 16. The muddle about reasons was not argued. And despite the great eminence of counsel appearing before their Lordship's House, Sir Sidney Kentridge, the point was not argued again before the Lordship's House. And you have that. You can't see that it wasn't argued. Lord Slynn is at volume 7, tab 65, paragraph 48. The appellant's printed case in Sardi is at volume 18, tab 180.
Sorry.
Volume 18, tab 180.
Yeah.
It's not reported in the law report, so we can't see the arguments in the weekly law reports. So we took the liberty of obtaining the case, the printed case, and it's very clear that the focus of the entire argument, the focus of the majority of the argument was on Article 5, and the only point made on domestic law was that the Immigration Act required a test of necessity before you could detain. Christian Liczynski wasn't cited. So this was obiter dicta in Sardi. and it's not with very great respect to all involved in the case, but with very great respect, it's not stable because it enshrines an unequal law, an unjust law, as Lord Bingham would say, and it enshrines discrimination under Article 14, read with Article 5.5. So those are my submissions on the reasons point. Mr. Goodman, grateful Mr. Goodman, the reference to Cullen is paragraph 7, page 1769, D to E.
Thank you very much.
Lords Bingham and Lord Steyn.
Dissenting.
The minority, yes.
Yes, you've got, well, Lord Steyn as well.
They're both of them with the dissent.
That really turns them into a majority. It really turns them into a majority.
What Steyn does. I see.
My Lords, just going back to the Roberts case, we say this was a case which Mr. Justice Bunby was correct to describe at paragraph 58 of his judgment as being uncomfortably close to home. This is an authority, if I may say so, laudably produced by Mr. Chamberlain, pursuant to his duties to the court, uncomfortably close to home. My Lords, my third point, I'm not going to say anything about. The third point was that the Secretary is under a duty to comply with the policy requirement to conduct a review. I'm not going to say anything about that at all. I need to spend some time on the paragraph 1.3 point. I'm going to take this fairly quickly given the time, and because its genesis is in the BID's case, which we adopt. Your Lordship's Ladyship will remember that paragraph 1.3 of Schedule 2 imposes a statutory duty on immigration officers to follow instructions issued by the Secretary of State in the exercise of their functions that are not inconsistent with the immigration rules. Okay, we make the following points. One, immigration officers are simply the Secretary of State's Carltona officers rather than creatures of statute. And that the authority for that proposition is Olada Hinde, volume 5, tab 45, page 302F to 303F. I should say Ms. Fulham's case sets out at paragraphs 26 to 27. I'm so sorry, my lords, my lady, I got a reference wrong. Mr. Justice Munby talked about uncomfortably close to home at para 67, not 58, 67. So that's the first point, Olada Hinde. The second point is that the manual here, the policy here, in relevant respects on the review question, is an instruction. Because it's in mandatory terms. And we rely for this proposition on the case of the Save Our Railways case, which you have, this is Lord Bingham, which you have at volume 17, 167, at page 597H.
Can you get that again? 17,
167,
yeah.
597H. Where his lordship's says that whether a policy directive is an instruction or guidance is a matter of ordinary language. This was a case concerning a very controversial issue of rail privatisation and franchising arrangements. The statutory duty is set out at the bottom of 596, Section 5 of the Railways Act 1993. It shall be the duty of the franchising director to exercise any functions assigned or transferred to him in the manner he considers best calculated to fulfil, and here are the critical words, in accordance with such instructions and guidance as may be given to him from time to time, any objectives given to him from time to time, with respect to various matters. 597F, the statute seems refreshingly clear. At letter G, the franchising director is to fulfil the objectives given to him by the Secretary of State under A, in accordance with such instructions and guidance as may be given to him from time to time. The bottom of the page, there's no reason to doubt that instructions and guidance bear their ordinary meaning. An instruction is a direction with which the recipient must comply. Guidance is advice which the recipient should heed and respect, should ordinarily be followed, but need not if there are special reasons for not doing. It's in the context of a statutory duty. Over the page 598B, the Act was Section 5 brought into force March 94. The following day, the Secretary of State sent to the Director objectives, instructions and guidance. At letter F, the next section was headed Instructions and Guidance. It opened with general guidance and terms, and then over at the following page, 599B, the relevant extract is quoted in full, the italicised passages being instruction, remember guidance. Frustratingly, you've lost the italics. I can tell you what they are because in the Smith-Burnell transcript, it was italicised, and the whole of paragraph 18 was italicised. In the second line, the whole case turned on the 4 words in the second line, is to be based. Yes. And then 21.3 was italicised, as was the last sentence over the page on 24. At letter B on 600, the crux of the dispute concerns the effect of paragraph 18, in particular the words based on, that being provided. And then the applications were made inter alia on that footing. The passenger service requirements were challenged. They were said to be broadly based on the current timetable. You get that from 600C in the first case, 600F in the second one. And then the legal argument presented by Mr. Sullivan QC, as he then was that the Secretary's instructions, this is the bottom of the page, 600, instructions in para 18 of his objectives, instruction guidance, did require the levels specified to correspond at least approximately to the levels provided by British Rail. And Lord Bingham held at 601D that the objectives, instructions and guidance define and circumscribe the statutory duty. The applicants accepted the words based on didn't require exact reproduction. Some latitude was permitted. Between F and G, Mr. Sullivan QC roundly rejected this argument. All that based upon requires is a starting point, that's G to H. And then Lord Bingham says based on is not a term of art, not an exact term, it permits some latitude. The changes must be marginal, not significant or substantial. That's at the bottom of the page. And then at 603H, after setting out evidence from the Assistant Director of the Franchising Director's Office, the approach that he had taken was intelligible, this is at H, intelligible and no way irrational, but it is not, in our view, an approach which gives effect to the instruction in para 18 or the guidance. So public law, rational, but didn't give effect to the statutory duty to comply with instructions and guidance. And this is perhaps interesting in a tangential way for our appeal at 604A. Mr. Sullivan urged that the Secretary of State had at all times known of and approved the approach of the franchising director. This is no doubt true, but the Secretary of State's approval can't alter the effect of his predecessor's instruction. He could have any time amended the instruction, he hasn't done so. We feel bound to accept the applicant's legal argument. This was a judicial review where you had discretion in play, and indeed, in the first case, relief was refused. You see that at 606H, owing to delay, but relief was granted at 607C. Not in our view apparent the grant of relief will serve no useful purpose. So this was a judicial review, and interesting that the statutory duty was not complied with, the decisions felt to be quashed, even when there was contemporaneous assurance through Mr. Sullivan that the Secretary of State approved of what the franchising director was doing. Here, if one's going down the causation route, one does not know what the Secretary of State would have done with certainty. I accept the force of the case against me, but one doesn't know. One has to construct a historical analysis.
But the statutory duty is all elevated on Section 5, isn't it?
But the equivalent statutory duty in our case is in 1.3, paragraph 1.3 of Schedule 2. I don't know if you ought to remember seeing that, but that imposes a statutory duty on the immigration officers. So we say that the manual is an instruction, that Mr. Ockleton, the final point I'll make on this, is that Mr. Ockleton, sitting as a Deputy High Court judge, regarded the OEM, the manual we're concerned with, Chapter 38, as an instruction in the case called Hattiger, which is Volume 12, tab 106 at paragraph 23. My Lords, that's all I'm going to say about this point. But if we're right and Mr. Fordham is right, then really you've got the statutory link. We say you don't need it for reasons that my Lord Lord Kerr raised a few minutes ago, but if you need it, it's there. My Lords, my fifth point is that not all public law errors concerning detention will give rise to a claim for damages. Not all errors will render continued detention unlawful. The issue is crystallised crisply in Mr. Tam's case at paragraph 3, where he says, halfway through the paragraph, is it enough for the detention to be lawful, as Secretary of State submits, to show that the detention is within the four corners of the statutory power and complies with the substantive limits laid down by the courts governing the exercise of that power? Or must it also be shown, as the appellant contends, that detention has been regularly reviewed in accordance with policy? Now, so the Secretary of State is essentially drawing a distinction between substantive limits, as he puts them, and procedural limits. We say that immediately raises a fundamental problem of principle and of practice. The fundamental problem of principle is that process matters in public law. See the great case of Cooper and Wandsworth Board of Works, where Mr. Justice Biles supplied the omission of the legislature in requiring natural justice to be complied with. This was an ordinary trespass action, where the lack of... My Lords will be well aware of the facts of it.
I think we studied our constitutional law rather longer ago than you did, Mr. Hussain. We may not all have these cases at our fingertips.
Oh, well, what happened is that the statute empowered the defendant to demolish the building if 7 days' notice hadn't been given. He'd only given 5 days' notice. So the defendant was acting within its statutory powers, but hadn't given notice of what it was about to do. And the defence, based on a statutory provision, failed because public law, process protections, natural justice, were not complied with. And there was no question about what would have happened had the plaintiff been heard. Could he have persuaded the defendant not to have pulled down his building? And one remembers the Cotton case, again, Lord Bingham, where...
The fat policeman.
I'm sorry? Yes, that's the policeman. We've got Cotton. Give you a reference. Give you the
Well,
reference.
I think we probably all remember it.
Yes. So process matters in public law, and process may yield substantive results. But then there is a categorization problem. What is process and what is substance? And I want, if I may, please briefly to take you to the case of Boddington at volume 7, paragraph 58. And first of all, we'll be familiar with the case. Lord Irvine, first of all, at 152E to F. Lord Diplock's categories are not watertight compartments because various grounds for judicial review run together. The failure to grant a person affected by a decision a hearing and breach of principles of procedural fairness may result in the failure to take into account relevant considerations. 155G. This is Lord Irvine explaining Lord Diplock in Hoffman-La Roche. Lord Diplock made it clear that the courts could declare it to be valid if the instrument was ultra vires by reason of its contents, patent defects, or reason of its defects in procedure followed, prior to its being made latent defects. Then 157E to F, and then this is the Bug case that was overruled in this decision. The approach was then elevated by the Divisional Court in Bug into a rule that bylaws which are on their face invalid or patently unreasonable, termed substantive invalidity, may be called into question by way of defence, whereas bylaws which are invalid can't, procedural invalidity. And then at 158E, in my judgment, the reasoning in Bug suggesting two classes of legal invalidity, and that's basically what Mr. Tan's doing, suggesting two classes of legal invalidity is contrary both to Anisminic and the subsequent decisions. Anisminic established, contrary to previous thinking, that there might be error of law within jurisdiction, that there was a single category of errors of law, all of which rendered decision ultra vires. No distinction to be drawn between a substantive and procedural error of law. And then 159C to F. Also, in my judgment, the distinction between orders which are substantively valid, orders which are procedurally valid, is not a practical distinction.
Tell me, I just don't actually understand what we're reading this for. I'm lost at the moment.
I'm sorry, it's entirely my fault. Mr. Tam is saying that it's unlawful detention if A, it's in the statute. It can be any substantive procedural, doesn't matter. B, at common law, public law, it's got to be substantive. It can't be procedural. And he says requirement to review is procedural, and therefore it's no good.
Where's the killer passage in Boddington?
I've just been reading this one, but I think I'm not doing very well.
Which one was that?
I'm not doing very well at all.
Right, okay.
It's
I'll take it that you've read them. Thank you.
And where do you
Mark them anyway.
Where do you find?
I think it's 158D2E is what you think is your
Thank you.
killer passage, don't
Yes,
you,
yes,
Mr.
yes.
Hussain?
Yes,
Thank you very much.
exactly right.
indeed.
But where do you find it in Mr. Tam's case? 'Cause
Yes,
he
that's
doesn't
what I
seem
was
he
getting
doesn't seem at all happy with what you're attributing to.
Which paragraph? Let's just show us the paragraph that you're meeting with this case.
He's saying that at paragraph 3, unless I've misunderstood something, he seems to be saying that he says, is it enough for detention to be lawful, as the Secretary submits, to show that detention is within the four corners of the statutory power? So that's the statutory preconditions, and complies with the substantive limits laid down by the courts. But not, he's drawing a distinction between processes, and then at 4, and then his case is then summarised in a series of propositions at 4, and 4C, again, is reflective of that.
Well, it's the kind of point where we'd perhaps be well advised to hear what Mr. Town actually says, and you can come back to it in a reply, but I doubt whether it's worth going any further at this point.
Yeah, and Mr. Fordham reminds me to... Yes, I was going to do that. Can I just give you more references? And then
Well, time is running rather against you.
Well, it's Lord Steyn at 170D to F.
Yeah.
In fact, he cites my friend Mr. Fordham as a modern commentator in support of the idea that these errors run together, procedural, substantive, and at 171 F to G, Lord Steyn quotes from the well-known passage of Lord Brown-Wilkinson in the Page case. Ultra vires is the central principle of administrative law. So, the point made by my Lord Kerr. My Lords, we accept that a line needs to be drawn somewhere. I indicated to you earlier where the line can be drawn. The issue is whether or not the error is sufficiently closely linked to the decision to detain, and the review certainly falls on the right side of it. I just want to say something about Cullen very quickly. Cullen was a case where and you have that at 871, volume 8, tab 71. This was a case where the false imprisonment claim, you've got the basics of it, it was the deferral without reasons of the right of access to a solicitor, contrary to what the statute required. Section 15 of the Northern Ireland Emergency Provisions Act, 1987. The false imprisonment claim was summarily disposed of in one paragraph each by Lords Hutton at paragraph 48. No substance in the submission. And note that this was a statutory requirement. But it had nothing to do with the detention. Mr. Town places some reliance on it. And Lord Millett at 61, again, did the same thing, summary disposal in one paragraph. The false imprisonment claim is hopeless. But interestingly, my lords, after he says that, 1784 at between D to E, this is Cullen, volume 13, tab 71, sorry, volume 8, tab 71, paragraph 61. My opinion is hopeless. His detention was lawful at its inception. And then these words, nothing that took place thereafter made his continued detention unlawful. The breach of duty would not have gone to the basis of his detention or the legality of the detention itself. That's the touchstone. And then my Lord Roger, agreeing with Lords Hutton and Millett, did not consider it appropriate to say anything about the false imprisonment claim. And the minority, Lords Bingham and Lord Steyn, didn't deal with it either. They simply decided the question of on the basis of an actionable breach of statutory duty. So this is, with respect, miles away from where we are. my sixth point was the context that this is an executive first actor. Contrast the cases of Walker, this is the IPP case, Norkayev parole board, and Dunn, which applies the parole board, which applies the Norkayev principle. Contrast those cases. Dunn indeed makes the point that indeed in Home Office, this is a Court of Appeal case concerning unlawful detention, where the Court of Appeal, or Justice Brooke, held that you could claim damages where detention was contrary to policy.
Tab.
Dunn is at 12103. D is at 982. Thank you.
Nine what?
D is at 982, volume 9, tab 82.
Sure.
But in the Dunn case, Lord Justice Thomas expressly distinguished D at page 742, paragraph 27, Roman 2, making the point that in D, the Home Office was the executive actor that was initiating detention. Executive first actor. And we say we are in Holbert Mohammed territory. We're in Roberts territory, save that there's an express statutory condition in Roberts. Arguably there is here because of the paragraph 1.3 point, but why should it matter? My Lord Clare. Mr. Tam makes the point in his printed case at paragraphs 34 to 36. He makes the point, what would be the return to a writ of habeas corpus, the authority or the review? And we say that is a neat forensic trick, because if you were to seek habeas corpus or judicial review, and we have in mind what's been said on the subject in recent times, in particular by Lord Brown in his Alba lecture in 2001, you would go against the first actor. You would need to go against the governor. You'd go against the first actor, which is the Home Office. And you can test the situation as follows. If a review decision is favourable, it would be no answer for the governor to turn up with the initial authority, any more than it would be an answer for the Secretary of State to say, oh, here's the initial authority. The governor could be sued. He wouldn't be acting on the four corners within the four corners of court order, but he'd be blameless. And if he was sued, he'd third-party the Home Office, something which in Evans couldn't be done because you had a court order. So it's the first actor, second actor distinction which we, with respect, say is a complete answer to my learned friend's points at paragraphs 34 to 36. My Lords, the seventh point was the deemed lawful custody point, paragraph 18.4 of Schedule 2. I'm just going to give you references. We would say with great respect that we were surprised to see the reliance that is placed on this, paragraph 25C of Mr. Tam's case, without citation of the leading authority on the point, which is the Mubai case.
Where's that?
Volume 17.
Sorry?
Volume 17, tab 165, page 256 E to F. Which cites the case of Green. You had a similar provision in emergency defence regulations in wartime, and there are two cases. Green at volume 17, 161, pages 116 to 117, And then Liversidge and Anderson at volume 3.
Give me the green pages again, please.
Green is 17, tab 161,
Yes.
pages 116 to 117.
Thank you.
And then Liversidge and Anderson at volume 3, tab 29, page 273. In the Sardi case in the Court of Appeal, Lord Phillips, Master Rolls the was cited the provision, but it went completely unnoticed. And that's at volume 8, tab 66, page 3134. There is an analogue of the provision in section 13 of the Prison Act. You have the Prison Act at 1.1, volume 1, tab 1. The correct interpretation of this provision was acknowledged in a white paper by the Home Office in 1998. That's volume 2, tab 13, chapter 12.1. And if Mr. Tam is right, this provision would breach Article 5.5, of course. My Lords, the eighth point is causation. You've heard my principal submission on that. One doesn't ask the hypothetical question of what could have been done, but rather what was done. And if what was done was unlawful, one doesn't ask whether something lawful could have been done. That's Roberts. It's Christian Liczynski. And again, it would be wrong if in ordinary law that is the position, for there to be some different test in public law.
So you're saying, does that mean that if, supposing that somebody were detained without a review for a month, let's say, and if there had been a review, the evidence suggests that the review would have authorised a detention. Does he get exactly the same damages as, is it quite irrelevant?
Our primary case is, yes, it is, and the authority for that is Roberts. It's what we would rhetorically ask, why should the source or status of the obligation to review make all the difference? The answer is Roberts. It seems odd at first principle.
Very odd.
Yes. Except that the law attaches supreme importance to the right to liberty. My Lord Hope said it is impossible to overstate its value in a democracy. In the Austin case, my Lord Hope cited the Strasbourg jurisprudence, the name of which I've forgotten, which places Article 5 in the first tier of protections.
I mean, I'm just asking us to, but I mean, what are the damages I mean, there's not been an inquiry in this case, of course, but I mean, what are the damages in wrongful imprisonment? I mean,
well, there are two measures. One is in Evans, where one discounts, one takes account of the fact that Mrs. Evans was already in prison, and she received, for 59 days imprisonment, £5,000. The other measure is a Thompson and Shoe. I'm afraid you haven't got that. We can provide that for you, where it's a higher measure.
I mean, Lord Justice Clark shouldn't have added, should he, at page 6698 in Roberts, especially, he thought it was too much, especially, or more than he'd have given, especially in circumstances in which if a review had been carried out at 5:25 a.m., his detention would have been lawful. That was a totally irrelevant consideration.
In our printed case, as a secondary submission, we say you can look at this question when it comes to quantum, and we say there is some support for this in Roberts, and that was the passage that I had in mind.
Is there a difference between common law damages and the Article 5?
Yes, because in Article 5, the court permits a national state to apply a causation test to quantum. But it's very important to note, it goes to quantum.
Yeah.
It doesn't go to liability.
Yes.
You asked the question in the Strasbourg scheme at 5.5, and Wassink is the authority for that proposition.
I mean, it's not saying quantimistic, but I mean, if he had a claim for special damages, it would be very curious if, if you were able to say, well, claim it on the basis that he would have, for something which he'd have got if he hadn't been detained. If he could say, well, actually, if he had been reviewed, he would have been detained.
Well, you go back to the analysis of what is the wrong.
Well, I accept there's a wrong. I mean, of course, and it may be that there's some sort of damages to mark the wrong. The question is, does it make any difference to the quantum? And if there were a claim for special damage, for example, it would be very curious if the defendants had to pay, even though they could show that actually, if the review had taken place, it would have been in anyway.
But there is a... Well, first of all, Roberts is an answer to that. Of course, it doesn't... It's the Court of Appeal. But Roberts is in line with a stream of authority which comes to what may be seen to be at first sight a rather paradoxical result. Christian Nijinsky is conclusive authority for the proposition that you don't ask the question, could another reason have been given for an individual's arrest, when in fact the reason given was the wrong one. And the rationale is that you impose a discipline on someone who is taking away your liberty. And that's important. And it's important in this case because of the kind of conduct that regrettably occurred in this case. It's important in this case because of of what is lurking in the background in this case, the Abdi point.
I'm not suggesting there isn't a wrong and that there might not be damages for the wrong. I think I'm really talking about the quantum of it.
Yes, but all those cases establish that you don't ask that question at that point either.
I'm worried about your mention of the Abdi point. I mean, I absolutely recognise the Abdi point may be of huge importance, but it isn't in front of us. And I just... So I don't see how you... What you just said was, that, so to speak, makes a great difference as a background to what we're doing here. But how do we know that?
You know it because Mr. Justice Davis's judgment in Abdi is on conventional principles, evidence of the facts found. And what he finds is that for 26 months, the Home Office were operating a secret, unlawful policy and misleading the courts.
And you tell us we've got to have regard to that here.
Your lordships are entitled to have regard to that as much as they are entitled to have regard to anything else.
Well, I mean, it's not the statement of facts and issues. I mean, I'm really concerned about this because, I mean, what you say, and it may be a huge case, but it's been adjourned until the Court of Appeal gives judgment in Abdi.
The case is called WL Congo in KM Jamaica. And
or whatever.
My understanding is that judgment is imminent, in fact.
Yeah,
but I entirely accept that the issues arising are not before this court.
I mean, I had supposed that we were supposed to deal with this on the basis of statement of facts and issues, and on the basis that the policy is, as in this document you showed us, is the agreed policy between the relevant dates, the Operations Enforcement Manual policy that we've been over with a fine-tooth comb.
Yeah. Well, Mr. Goodman rightly reminds me of paragraph 16 of the Statement of Facts and Issues, which says that at the time
Common ground, last sentence.
Yes.
Common ground that the impact of the policy does not give rise to a discrete issue in this appeal.
Well, I'm not suggesting it does. All I'm saying is that Abdi, the judgment of Mr. Justice Davis in Abdi, is evidence that this was not a one-off aberration. WL, in that case, his detention was not reviewed for a very protracted period of time. I think it was in the order of the same period, 10 months or so.
Well, there's plenty of stuff in the papers about how, they never got near to implementing the review policy as they were meant to. But to say, as I understand you're inviting us to regard it, that was intentional, or because they had changed the policy and they were going to lock them up either way. I mean, it's a dramatically different case.
I can't ask you to do that because I'm sorry to say this, but the evidence which could have shown that was only disclosed in the week before the Court of Appeal hearing.
Yes, and we don't have the views of the Court of Appeal on the point, for obvious reasons. We don't have the views of the Court of Appeal because the point was...
Because the evidence wasn't disclosed by the Home Office until a week before the hearing in the Court of Appeal. But you have... Yes, the evidence that there were ministerial communications on the point was not disclosed until 8:05.
Well, we understand all that, but I mean, paragraph 42 of the Court of Appeal or Justice law says it is in principle agreed between the parties that the new issues which thereby fall to be determined from all these late disclosed documents should be remitted for decision by the High Court. Well, then we've got to ignore them, haven't we? I mean...
We would respectfully submit no. You're entitled to look at what Mr. Justice Davis found in the Abdi case. What he found was... It goes to the discipline point. One of the functions of the tort, the need for the discipline, the need to call the Secretary of State to account.
But you can call him to account because he's failed to do what the policy you showed us requires him to do. On the discipline point in this context, of course, I understand entirely.
Yes.
Or you can discipline him for having a secret policy, but that's not before us.
It doesn't go to any... It doesn't go to a legal issue, but it goes to a public policy issue, we would respectfully submit. I think my lords have my submission. I'm not sure I can prove on them.
Well, it's 5 to 4. I think you should try to complete your submissions
My lord, yes.
in the next few minutes.
I'm happy to reply on causation. Perhaps that would be sensible. And then that enables me to move to Article 5. The argument is set out in our printed case at paragraphs 100 to 121. It's important both in its own right and as far as our common law submissions are concerned. And we cite the Evans case again as authority for that, for the link between Article 5 and the tort. Evans you have at volume 7, tab 64. My Lord Hope considered the match to be of interest at page 37G. Lord Steyn considered the match to be interesting at page 29E, and Lord Hobhouse considered at page 46H it to be highly persuasive. I want, if I may, to look at Mr. Tam's case at paragraph 74. And his proposition is, first of all, that if we succeed, Article 5 doesn't add anything. We accept that. But if we lose at common law, he says again, Article 5 doesn't add anything, because page 33, if, on the other hand, on a proper interpretation of the statutory scheme, the decision to detain is effective to authorise detention until such time as the decision is taken to release the deportee, the failures to carry out detention reviews do not engage Article 5.1 at all, because the deprivation of liberty to which it applies had already taken place. Now, we say that is not a tenable submission with great respect, because it regards the deprivation of liberty under 5.1 as a one-off act at a historical point in time, akin to a court order, and indeed, in support of his submissions on Article 5, he cites a number of the prison cases. So you have Walker at the bottom of 76 and Dunn at paragraph 80, as if the executive act of depriving you of liberty under 5.1f was the same thing as a court order under Article 5.1a. It is no such thing, with great respect. If it was, you could not have cases which said that Article 5.1 will be breached, 5.1f will be breached if deportation is not conducted with due diligence, if it's overlong. They simply wouldn't go to the Article 5.1 question, because you'd have had the deprivation of liberty. Historically, you'd have had it. They wouldn't engage Article 5.1 on his analysis.
I'm sorry, are you saying if there's a Hardiel-Singh breach, that is a breach of 5.1f? Is there authority for that?
I'm not saying that, but that is right. And the reason why that's right is because any breach of domestic law automatically yields a breach of Article 5.1. That's the point that my Lord Hope made in the Evans case. You've got to have, the deprivation of liberty has got to be in accordance with law, national law primarily. But I haven't made my point properly. The point I'm making is that Mr. Tam, at the end of paragraph 74, is saying that the deprivation of liberty takes place at time 1. And that's it. And therefore, subsequent detention reviews, the failure to conduct them, does not engage Article 5.1. That's what he's saying.
So you say you look at each stage, at each failure to conduct the review, that raises an Article 5 point, you say?
Absolutely. It's a continuing act.
Well, of course, if you're right on the home front, that no doubt is right. But if you're wrong on the home front...
No, on articles... my Lord, if we put the home front aside, we just look at Article 5, Mr. Tam's absolutely right if this was a 5.1a case. The deprivation of liberty in a 5.1a case is a historical act, and it justifies detention for the duration of the deprivation of liberty. And the causal connection needs to remain intact. It will remain intact, save in extreme circumstances if the parole system breaks down.
Yeah.
But in the 5.1f cases, you get a breach of 5.1f if detention is overlong.
If what?
Detention is overlong. It takes too long. Or if proceedings are not pursued with due diligence.
Well, that's a Hardiel-Singh point again.
Yeah, it's also Strasbourg. Strasbourg says that most recently in the Grand Chamber in the Belmarsh case, and others.
I suppose what you can say is that irrespective of Hardiel-Singh, supposing that hadn't been decided, Strasbourg would be saying the same.
It does say the same.
Yes.
Exactly, my lady.
Yeah.
And it's our case at paragraph 104 at page 39, where we set out 3 Grand Chamber authorities.
Your para 39, you say?
104 at page 39.
Oh, sorry. Page 39.
Where we set out 3 Grand Chamber authorities. Chahal is a Grand Chamber, Sadi is a Grand Chamber, and Belmarsh is a Grand Chamber. They all say that detention mustn't be overlong, and proceedings must be in progress and pursued with due diligence. And you have the paragraph references. The tabs are, Chahal is volume 13, tab 117, paragraph 113. Sardi is at volume 14, tab 126, paragraph 68 to 74. Belmarsh, that's the A case, is volume 14, tab 128, paragraph 164. The point is, as my lady says, ignore Harding. Imagine it never existed. This is what Strasbourg is saying. If it is saying that, then a deprivation of liberty cannot be a one-off historical act. It's got to be a continuing act, which of course it is. We respectfully submit on any sensible view. You could not have detention being in violation of Article 5.1f by reason of its over-length, by reason of the failure to prosecute deportation sufficiently diligently, if the analysis was, oh well, deprivation of liberty has taken place historically, and that's it. Which is what Mr. Tam is saying. He says the failures to carry out detention reviews, subsequent to detention in parentheses, do not engage. That's a word which has been deprecated, I know, but don't attract the protection of Article 5.1 at all, because the deprivation of liberty to which it applies had already taken place. And that is inconsistent with at least 3 Grand Chamber authorities in Strasbourg.
Well, I think you're beginning to repeat.
I am, I'm so sorry. Those are my submissions. Yes. Unless there's anything I can assist
Thank you very much. Mr. Goodman, are you wanting to add anything? Thank you very much indeed. Well, Mr. Fordham, we'll look forward to seeing you at 10:30 tomorrow morning. As far as timing goes, according to the arithmetic which is before us, if you spoke for the time that's advertised, that would give 5 minutes for Mr. Hussein's reply. Perhaps you particularly, because we have your intervention in writing, would like to consider whether you really need the full hour.
Of course.
Because obviously Mr. Tam has an interest in...
To assist the court and the parties.
Yes.
Who are able to
Yes,
do
well,
better than that. If the court were able to have a look at our case and the contextual points in the witness statement, that would certainly help.
Yes, well, we'll do
Very
that.
good.
Thank you very much indeed.